Welcome back, everybody. This is Michael Levitis from JurisQ.com with Stephen Yuniver, a partner in Sinayskaya Yuniver, a law firm here in New York. Stephen, welcome back.
Thank you, Michael, for having me.
Thank you for your time. Thank you for educating our viewers and our listeners. And we educate with you people on commercial real estate, on doing business in New York, on incorporating. And today I want to talk about evictions. It's not pleasant, but it's out there, so we have to talk about the process of evictions in commercial setting. It's no secret that during COVID times, evictions came to almost complete stop, if not full stop. Now the courts are back in session, right? The landlord-tenant courts are working. Supreme Court of New York is working, and once again, the process is back on. So can you tell us, first of all, what is the status right now of evictions in the commercial setting in the state of New York?
Sure. So evictions in the commercial setting and back in New York are back on. They are delayed. Back a few years ago, there was still, you could evict somebody within a few weeks in a commercial setting.
Really?
Now it takes months.
Mm-hmm.
Judges want to make sure there's enough time financially that you could get the help you need. There's also a few years ago, there was a case called the Yellowstone injunction case.
Yeah, what is that? I heard of a show, Yellowstone, in Paramount.
So Yellowstone injunction,
yeah,
well, I guess it's kind of like the show. Not
okay.
really. So basically,
is there drama involved? A lot of drama?
There's a lot of drama.
Okay.
You take, well, as soon as a landlord sends you a notice that you're going to get evicted, you have the ability, a tenant could file something called a Yellowstone injunction.
Okay.
An experienced attorney should do this, that handles landlord-tenant law and goes to court. But basically, you file a Yellowstone injunction only in Supreme Court. Civil court doesn't have the jurisdiction to hear them. And that effectively stays a civil court eviction case.
And when you say state, I just want to translate in plain speak, non-legalese. Stay means that it's paused, right? The action
it's paused, it's put on hold until the Supreme Court, the higher court, makes a decision as to why you think it should be stayed. And it's not for monetary, let's say you're getting evicted for a holdover or something else. It depends on what it is. A holdover is when you stay beyond your lease.
Okay.
So the question here is, the tenants have, during the pandemic, they changed quite a bit of the laws, added a lot of executive orders. Executive orders are orders created by the governor or the mayor,
right?
Whoever the executive of the municipality is, to stay these cases. And it also depends on the jurist that you have, the judge that you have that will decide your eviction case. The landlords should really understand as well that there's certain protections that you put in your lease.
First, can you just go back to Yellowstone?
Sure.
If you file for that injunction, how much of a reprieve do you get? Approximately how much time?
So it's not so Yellowstone injunction, when you file, it's some kind of motion that you file with the court. The judge actually picks the date.
I see.
I've seen a judge pick a date within a few weeks, and I've seen a judge pick a date within a few months.
Okay.
So when we talk about evictions in New York, we're talking about months. We're not talking about years.
Got it.
Most of the time.
So it gives you like a second bite at the apple. Gives you a second judge, if you will, to look at your case. Is that what you're saying?
It definitely gives you another judge that it wouldn't have been if you were being evicted. And the other one, there's also bankruptcy protections and other variations that every tenant who's behind on their rent should talk to an experienced lawyer that would understand that.
In other words, if you file for bankruptcy, right, you also get some kind of a pause until the bankruptcy is adjudicated, determined.
Yes, I haven't done those in a few years, but I think it was like a 546 or 543 stay, something like that.
Gotcha.
And those are a stay for a short amount of time. I don't remember the dates exactly, but that you could also stay. It gives you an opportunity to negotiate with the landlord on how to get as much rent reprieve, rent kind of rebates as you can.
Very good. And what about on the landlord side? What can the landlord do to protect themselves? Either by putting something in the lease or do something in the eviction proceeding.
Well, for most landlords, luckily, in New York, we're finally past the stays of evictions for people who have for non-payment. They were stayed for a couple of years because of COVID.
Right.
Unfortunately, in places like California, it's still it's still stayed. So, but in New York, the best thing to do is really give yourself a strong enough lease. The problem is a lot of the leases that were written prior to the pandemic, or some people wrote their own leases, especially in commercial settings, get thrown out quite often. For the reason is that they put clauses in there that are not proper legally, and like you in New York, it is actually illegal to waive a Yellowstone injunction.
Interesting.
So I've seen leases where the landlord requires a tenant to waive a Yellowstone injunction. Like, right, I hereby waive my right to a Yellowstone injunction.
I see.
You can't waive your right to a Yellowstone injunction in New York, even if you want to.
Got it.
So that being said, a judge might say your lease is not proper, therefore I'm throwing this out, and therefore come back. So landlords really do need to protect themselves by having the lease written properly according to all the legal terms of New York. I mean, these are contracts. You're supposed to, I wouldn't, I don't think I'd be wrong to say that these are thousands of dollars a month in income that you have. You should have a proper lease. I don't think anybody rents commercial space for under $100 a month.
Yeah, Steven, you and I did a whole session in the beginning when you first started to participate in our network with JurisQ about pitfalls in a commercial lease. And we're now hitting the same topic, how important it is to go to an attorney that does this for a living, that does commercial real estate, not only on a transactional side, where you know the lease clauses, but also on the litigation side, like your firm, where you have seen what actually happens on the battlefield. You see what happens in court when landlords or tenants try to use lease clauses or try to use different defenses afforded to them by law in trying to stave off eviction or force an eviction. So that's why we just want to reiterate again how important it is to go to an attorney before you sign a lease, or for a landlord to consult an attorney before they draft a lease. Don't just draft a lease by your paralegal in your office or your in-house people. I think, Stephen, any landlord of any size should go to an attorney, correct?
Correct. I just had a horror story a few days ago
where I love hearing those. I love hearing those. Because you know why? Because they shed light exactly of what could go wrong.
I think this is more rare than, but it just, if this came wrong, it was a commercial building in Soho.
Okay.
It was a fourth floor elevator building, commercial space, art gallery. And in the lease, they wrote something in a commercial lease, and the lease was about $15,000 per month. $15,000 per month just for on the fourth floor. So you can imagine the building.
Of course.
And the judge in that case found that it was an improper lease, and this should have been something was a residential comment in the lease where they were allowed to be a bedroom, turned it into a residential lease. A judge decided this, and now lowered the rent to the last rent controlled amount, which was I think 900.
Wow.
So
that's a killer.
And then turned it into a rent controlled apartment. So therefore, a $15,000 per month unit was turned into a $900 per month unit for the remainder of the person's life that's living there.
What a horror story. That is incredible.
I felt terrible for this landlord. And it was all about for not using the proper documents.
Exactly. It's all about also due diligence about your own building, doing the right research, and also drafting the right clauses in your lease. So these horror stories, they're horrible, but they illustrate for people of what can possibly go wrong. And as we know in New York real estate, a lot of things can go wrong.
Right.
With that positive thought, I want to leave off and say that on a positive note, you do have attorneys like Steven Yuniver that do this day in, day out, and we're able to tap into Steven's knowledge because you have seen cases. You can see, you have seen what could go wrong, and thank you for educating the people on it. And if anybody wants any specific advice on your situation, on your building, or on your lease you're about to enter into, you're welcome to call the law firm of Sinayskaya Yuniver. The phone number is on the bottom of the screen. Thank you, everybody, for tuning in. And next time, we're going to bring in Steven for one more very important question, one more pitfall to avoid in a lease. Steven, you just told me about this, and I was floored that sometimes, get ready for this, sometimes the landlords sneak in a clause into a lease that says if you sell your business, the landlord gets a cut of the business. This is unreal. It's something you must avoid, and we're going to talk about this clause and what you can do in our next session. Please stay tuned. Thank you.